Seconds to go. Start. The primary source of the public law proceedings stems from the prerogative writs, and the courts have therefore to evolve new tools to give relief in public law by molding it according to the situation with a view to preserve and protect the rule of law. While concluding his first Hamelin lecture in 1949 under the title Freedom Under the Law, Lord Denning, in his own style, warned, "No one can suppose that the executive will never be guilty of the sins that are common to all of us. You may be sure that they will sometimes do things which they ought not to do, and will not do things that they ought to do. But if and when wrongs are thereby suffered by any of us, what is the remedy? Our procedure for securing our personal freedom is efficient. Our procedure for preventing the abuse of power is not. Just as the pick and shovel is no longer suitable for the winning of coal, so also the procedure of mandamus certiorari and actions on the case are not suitable for the winning of freedom in the new age. They must be replaced by new and up to date machinery, by declarations, injunctions, and actions for negligence. This is not the task for Parliament. The courts must do this. Of all the great tasks that lie ahead, this is the greatest. Properly exercised, the new powers of the executive lead to the welfare state, but abused, they lead to a totalitarian state. None such must ever be allowed in this country. In the case of Common Cause, a registered society versus Union of India and others, this court observed thus: bad faith on the part of a public officer or authority will result in civil liability where the act would constitute a tort, but for the presence of statutory authorization, as Parliament intends statutory powers to be exercised in good faith and for the purpose for which they were conferred. Proof of improper motive is necessary in respect of certain torts and may negative a defense of qualified privilege in respect of defamation, but this is not peculiar to public authorities. There exists an independent tort of misfeasance by a public officer or authority, which consists in the infliction of loss by the deliberate abuse of a statutory power or by the usurpation of a power which the officer or authority knows he does not possess, for example, by procuring the making of a compulsory purchase order, or by refusing or cancelling or procuring the cancellation of a license from improper motives. However, where there has been no misfeasance, the fact that a public officer or authority makes an ultra vires order or invalidly exercises statutory powers will not of itself found an action for damages. D. Smith, in Judicial Review of Administrative Action, while speaking of tort of misfeasance in public office, says as under: a public authority or person holding a public office may be liable for the tort of misfeasance in public office where there is an exercise or non exercise of public power, whether common law, statutory, or from some other source, which is either affected by malice towards the plaintiff or the decision maker knows is unlawful, and the plaintiff is in consequence deprived of a benefit or suffers other loss. D. Smith further says as under: a power is exercised maliciously if its repository is motivated by personal animosity towards those who are directly affected by its exercise. Where misfeasance is alleged against a decision making body, it is sufficient to show that a majority of its members present had made the decision with the object of damaging the plaintiff. Often there may be no direct evidence of the existence of malice, and in these circumstances, the court may make adverse inferences, for example, from the fact that a decision was unreasonable, that it could only be explained by the presence of such a motive. A court will not entertain allegation of bad faith or malice made against the repository of a power unless it has been expressly pleaded and properly particularized. If the executive in an arbitrary manner demolishes the houses of citizens only on the ground that they are accused of a crime, then it acts contrary to the principles of rule of law. If the executive acts as a judge and inflicts penalty of demolition on a citizen on the ground that he is an accused, it violates the principle of separation of powers. We are of the view that in such matters the public officials who take the law in their hands should be made accountable for such high-handed actions. For the executive to act in a transparent manner so as to avoid the vice of arbitrariness, we are of the view that certain binding directives need to be formulated. This will ensure that public officials do not act in a high handed, arbitrary, and discriminatory manner. Further, if they indulge in such acts, accountability must be fastened upon them. While we consider the issue in this case, we will have to reiterate that even the incarcerated individuals, whether accused, under trial, or convicts, have certain rights. As any other citizen, they have a right to dignity and cannot be subjected to any cruel or inhuman treatment. The punishment awarded to such persons has to be in accordance with law. Such punishment cannot be inhuman or cruel. This court has protected the prisoners from excesses and arbitrariness of the state and its officials. In the case of Sunil Batra versus Delhi administration and others, the court declared that the use of iron fetters or the practice of solitary confinement and cellular segregation is inhuman. Speaking for the court, Justice Krishna Iyer, in his inimitable style, states that again, in the case of Charles Sobraj versus Superintendent Central Jail Tihar, New Delhi, while observing that the rights enjoyed by prisoners are not static and will rise to human heights when challenging situations arise, this court observed thus: prisoners retain all rights enjoyed by free citizens except those lost necessarily as an incident of confinement. Moreover, the rights enjoyed by prisoners under Articles 14, 19, and 21, though limited, are not static and will rise to human heights when challenging situations arise. In Sunil Batra versus Delhi administration, the court highlighted Article 21 protects the prisoners against several inflictions. It was held inflictions may take many protein forms apart from physical assaults, pushing the prisoner into a solitary cell, denial of a necessary amenity, and more dreadful sometimes transfer to a distant person, where visits or society of friends or relations may be snapped, allotment of degrading labor, assigning him to a desperate or though gang, and the like may be punitive in effect. Every such affliction or abridgment is an infraction of liberty or life in its wider sense and cannot be sustained unless Article 21 is satisfied. This court recently, in the case of Sukanya Shanta versus Union of India and others, reiterated the constitutional rights of the accused in the following words: the right to live with dignity extends even to the incarcerated. Not providing dignity to prisoners is a relic of the colonizers and pre colonial mechanisms. Stop.